Hello and welcome to our recording today. It's a new series that we're running called Practice Across the Pond, and we're focusing on both the US and the UK angles on lots of really hot topics for professional services firms. Today, we're focusing specifically on ethics and on regulation in professional services context, and particularly in the legal services regulatory context. I'm really delighted today to be joined by my partner, Andrew Pavlovic, and a special guest and a co-star for this mini-series on Practice Across the Pond, Devika Kewalramani. I think we're going to start off, if we may, with an introduction, really, to how each of our respective jurisdictions are regulated. And I wondered if I could come to you first, Devika, just thinking about how regulation works in overview in the US and in your particular states, just to give us a flavour of the backdrop.
Thank you so much, Corinne. Happy to be here. In the US, the American Bar Association has its model rules of professional conduct, which really serves as a national framework for professional conduct. These have largely been adopted by individual jurisdictions across the nation, and with some variation, some have adopted them wholesale. Violation of any of those rules of professional conduct, once adopted by the states, would lead to professional discipline. Now, the model rules themselves are not binding on lawyers or law firms, but once states have adopted those rules, those are binding, and violation can obviously turn into something really terrible. Now, in some states, it's not just the lawyers who are bound and are governed and regulated by the rules, but law firms as well. For example, in New York, of course, lawyers are subject to legal, professional, regulatory, and contractual obligations. But in terms of professional conduct, we largely have a self-regulating system. That doesn't mean that we don't need to comply. We have to comply, and we have rules that require us to report another lawyer's conduct as long as they meet certain threshold requirements, such as a lawyer having actual knowledge of a substantial question of professional misconduct by someone else. We also have to report our own conduct, but that is of a nature of, it's a much more serious kind of situation where there may be criminal conviction involved. In terms of law firms and how we regulate, there are specific rules built in for supervisory lawyers, lawyers who are partners, those who have management level authority, to ensure compliance of the rules by lawyers and non-lawyers at the firm. And they are accountable for non-lawyer conduct and the conduct of junior lawyers. They are responsible for it, and they must make sure that they adequately supervise. And that's a term of art. And that's not to let off junior lawyers off the hook. They are also independently responsible for their own conduct, regardless of who is asking them to do what. So that's the structure. We have these internal rules that require us to do things, but we also have the overarching regulatory system where, whether it's bar associations or grievance committees like in New York, there's enforcement, and in other words, there's review, there's investigation and prosecution, and it could lead to professional discipline, which could be either private or public.
Thank you so much. Really interesting. And Andrew, it would be really helpful just to hear, just by way of comparisons, some remarks on the UK system. Although hopefully, I know we have a number of UK lawyers that this will be a refresher rather than news to them.
Yeah, so we start off with the Legal Services Board, which is the oversight regulator. And then underneath that, you have several different regulators. So the Solicitors Regulation Authority for solicitors, the Bar Standards Board for barristers, etc., etc. I'm going to focus today mostly on the Solicitors Regulation Authority. The SRA has principles which apply to individuals and firms, then specific codes of conduct for firms and individuals, and then various other rules relating to, for example, accounts rules, authorization rules, etc. They investigate allegations of misconduct, which may be raised by clients or third parties, or similar to what Devika said, by firms themselves in accordance with the self-reporting obligations, or by the other side in transactions who also have those obligations. They have their own fining powers, so they can investigate and fine. In traditional law firms, that's fining powers are up to 25,000 for firms and individuals. For licensed bodies, such as alternative business structures, they have much higher fining powers. If a case isn't suitable for a financial penalty, then they'll refer the matter to the Solicitors Disciplinary Tribunal, which is an independent tribunal which has a chair, a legal person, and a lay member. And the sanctions there could range from suspension from practice to being struck off the roll in the most serious cases. And similarly as well, they can take action against individuals and firms. So when they take action against the firm, they're looking at whether the firm's culture, systems, or processes, or the lack of those things, has either caused, contributed to, or exacerbated the misconduct. So in a typical case, you might find a solicitor is brought before the tribunal along with the firm, and the reason for bringing the firm into the case is because there's perhaps been a lack of training, there's a lack of supervision. So something systemic has occurred, which means that the firm should also be held responsible. And we'll probably go on and look at some of these topics in more detail, but there's a lot more focus and emphasis on sort of firm culture and systemic issues at the moment with the SRA.
I think you're absolutely right. The whole reason for this mini-series is to explore a number of those issues in a bit more detail. I know we've got a few ideas of some of the things we want to focus on today. Things like conduct, things like conflicts, which are things that come up quite often. But I thought just before we get into those sort of detailed topics, it would be really interesting to hear if there are any sort of hot topics at the moment in sort of professional services regulation in each of your jurisdictions. Maybe Andrew, you mentioned conduct already. Would you say that that's one of the really key areas of focus at the moment in the regulatory space in the UK?
Yes, so definitely there's a focus on misconduct in the workplace and workplace environments, and how that can lead to other forms of misconduct, such as dishonesty, where people do something dishonest to cover up a mistake they've made. Another key theme at the moment is actually the issues that General Counsel themselves face in balancing their own regulatory obligations with the sort of the need to act in the best interests of the company, and how they can be placed under pressure sometimes, particularly when maybe this doesn't apply so much to law firm general counsel, but to more commercial general counsel acting in a commercial environment, where they might be under pressure to do certain things which might require them to bend their regulatory obligations. And we're seeing quite a few high-profile cases at the moment where those sorts of issues are being played out. So I'd say that is also a key theme at the moment, and the SRA has just published some guidance for General Counsel on how they can try and manage those sort of competing obligations.
Does that resonate with what you're seeing in the US, Devika?
Yes, largely I think for General Counsel today, especially those who are managing global firms, or at least international or large domestic firms, managing risk is, I think, a big challenge, because risk is coming in many different shapes and forms, whether it's legal, ethical, professional, regulatory, contractual, or business risk. And understanding and respecting the culture in these different offices or locations, if you will, while balancing compliance obligations that might be local, and consistency of policies and practices that are constantly being developed to address new issues and evolving problems that were not considered yesterday, but have become a big thing for tomorrow. So we have to deal with it today. And I think another really big piece of General Counsel's job today, which may not have been that significant in the old days, is that need to continue to build awareness and education and training on three key areas: artificial intelligence, how to use it, when to use it, what policies and practices to put in place, and constantly tweaking that policy, because where we were with those forms of policies and the tools that were available 8-9 months ago has radically shifted today. They're much more sophisticated and advanced tools. So how do we use them, and and how do we avoid risk? Lawyer well-being and mental health is another issue when largely that in the past it may have been viewed as something that was less a GC's concern, but today that's tied to a number of different things in terms of delivery of services, having the right resources available. And finally, diversity, equity, inclusion, and belonging. That's another piece of this. So I would say AI, lawyer well-being, diversity are sort of key issues. All of these things that I've mentioned are also tied in very closely with many of our firms that deal with highly regulated clients who want to know what their law firms are doing with regard to these issues. And so I see them as large concerns, and they're going to get only bigger.
One of the things that when we're preparing for those discussions, talks a little bit about, and one of the challenges that we understand international law firm GCs face regularly is trying to marry up to sometimes inconsistent regimes of regulation. And one area we identified particularly was the issues of conflicts and how to manage potential conflicts across a global organization, but also in face of the different rules that you find in different jurisdictions. And I wondered whether we could talk just briefly about what the kind of the key constraints, what the key sort of regulatory principles are there on conflicts, and then we can explore together how they fit and how you make that work internationally. And I wondered, Devika, whether you're able to talk to us at a high level about what's expected really in terms of managing conflicts.
Yes, it's really a complex issue because it comes with a whole baggage of very complicated rules and requirements, especially when you have multiple offices with different regulations. You have a variety of clients, and there are different types of matters. So I think the key concern becomes how to comply with the rules, which are very robust on conflicts of interest, while meeting the client's imperatives, because clients have their outside counsel guidelines. They have their own separate conflicts policies and conflicts forms, and lists of subsidiaries and affiliates that have to be fed into the law firm's databases and kept current and up to date. So the main issues I would say we worry about with conflicts is identifying the client. So is the limited liability company the client or the individual members? Just to give you an example. And then the issue of adversity. What do you do with corporate relatives of an organizational client? The rules in many jurisdictions say, well, the law firm might be able to be adverse to the corporate relative of an existing client. But then, there are circumstances and factors to look at. But many outside counsel guidelines will say that the client is everyone that is related to the particular client that the law firm is representing. So those inconsistencies have to be ironed out. Types of client become an issue because there are different rules in the US for the type of client that there may be a conflict with, whether it's a current client, a former client, a prospective client, or a client that the lawyer may be looking to do business with. That's a more specialized variety of a conflicts problem. And the type of matter becomes an issue if it's litigation, transactional work, or some form of advisory work. So the initial question is it a conflict, and how do you analyze and resolve that? And then if it is a conflict, then how do you set in place waivers or ethical screens that may be needed? And clients have their requirements when it comes to that. So largely, this is a substantive issue. It's a key risk issue for law firms because they're dealing with these issues all the time across offices. But it's also largely about the policies in place, the practices, and the procedure. And some of the issues that are really difficult to deal with, again, whether it's within one office or across multiple offices, it's the same issue, and that is conflicts imputation. So if one partner at a law firm cannot take on a matter because of a conflict, no one at that firm, however large or small, can take it on. Of course, that kind of disqualifying feature can be waived, meeting certain requirements. And then in New York, we have a very unique conflicts checking rule that requires us to check specific things. Firms across the country also do conflicts checking, but we have a rule that actually tells us what needs to be done. And violation of that rule itself could be in itself professional discipline. And so taking the conflicts checking rule together with the conflicts imputation rule, there's a violation. Both the lawyer involved and the firm can be held responsible. So these are very strict and rigid rules with, some room for interpretation, of course, and careful analysis.
Thank you. And that resonates actually, Andrew, doesn't it? In terms of thinking about the fact that it's not just a responsibility of the firm to check there's no conflicts, that the individual has that responsibility too. Would you mind just sort of giving us an overview of the constraints that UK regulated legal professionals have?
The Code of Conduct identifies sort of three main conflicts. The first is an own interest conflict, where the firm or the individual's own interests are in competition with the client for some reason. The firm has a particular interest in the matter which conflicts with the client's. You then have the actual client conflict, so the circumstances in which you can act for two clients in relation to the same or a related matter. And then finally, you have confidentiality conflicts, which is where you're acting for a client, where you hold relevant information in relation to that relation to their matter from a previous matter. And the rules talk about the circumstances in which you can act in those latter two circumstances. You can never act where there's an own interest conflict. In relation to the client conflict and the confidentiality conflicts, you can act where there are things like information barriers and consent is obtained, etc., etc. But some of the largest fines that we've seen in the tribunal have come from firms that have acted to clients in client conflict. And again, maybe this is something Devika can comment on, but I know there was a case in the US regarding Denton's and the Verine structure, which suggests that having a Verine structure doesn't mean that you can say, well, that's a different office. We don't have to worry about that for the purposes of a conflict. So I think from an international perspective, it needs to be quite a very wide search to make sure that you're not going to fall foul and find that some other office has acted for a client somewhere down the road.
So let's think about some of the practicalities then, because you've got your system for checking conflicts within your organization, and something comes up where there's a potential issue, some sort of conflicts issue. I guess I'm really interested how the GC team or the risk team resolve those issues and make a decision. So to your point, Devika, about whether somebody can act or no one can act in those circumstances. And I don't know, Devika, whether you can sort of shed some light in practice when you're looking at firms that are US headquartered. Is this a management question? Is it left with the risk team? Are there very strict policies and procedures which make it like a flow chart? I'd be really interested in some insight in terms of how those issues are resolved and how decisions are made in practice.
I think we're all still scratching our head as to how to have the perfect system in place. And it has to be an integrated approach, because there are a couple of different tiers here. We've got the operational side of this, which is essentially having the conflicts database that is fed information and data that has to be constantly kept up to date and accurate and complete. That has to be analyzed by the conflicts analysts who run the searches, who produce the reports, and then who communicate with both the lawyer bringing in the matter, which might be creating the conflict, and the the impacted client or the lawyer handling the matter, the existing matter where the conflict is coming from. So there's that coordination that the conflicts analyst or whoever has that title of running the search and coordinating the search process and the reporting of that. That's one piece of it. And then there is the other piece, which is the review of that by the lawyers who are involved in the conflict, but more independently and objectively by those who are not. Whether it's the ethics committee or the conflicts committee internally, consisting of lawyers who look at situations where there's either a potential conflict or an actual conflict. So you've kind of got the substantive piece of this, the legal side of it, where you're looking to see whether there's a conflict, which means, is there adversity? And why do we care? Because we have these rules requiring us to owe a duty of confidentiality and a duty of loyalty and a duty to exercise independent professional judgment so that that's not compromised. And so those are the principles underlying why we go through this whole process of identifying conflicts and trying to resolve them. And I think that the analysis is so important, and it can be a time-consuming and a thoughtful process, but too quick a decision when it's a complicated, maybe sprawled across different countries or different offices, or involving very complex corporate structures or restructuring, and looking at that very closely to make sure that something hasn't been lost in the analysis. I think that is equally important as the more technical side of checking conflicts, where you don't want to miss checking a name or miss spotting a conflict when there is one, which is more on the operational side, or making a technical error. I mean, those are the easiest ones that lead to malpractice claims and sometimes disciplinary complaints and investigations and sanctions. In terms of the management team being concerned, I think these kinds of situations, depending on the relationships with the client, depending on the work involved, depending on the urgency, the delicacy, the sensitivity, and the type of conflict that we're speaking about, can really escalate this to a management problem. There could also, aside from the pure ethical piece, there could be a business-related issue here with the conflict or relationship problem, which then is ripe for management team review. And so I think that this is sort of a team approach to conflicts on many levels, involving those running the conflicts, those reviewing it, management, and having as many resources available to resolve these conflicts, because they have to be resolved correctly and quickly. Otherwise, the clients are going to, clients want these things resolved quickly. Their matters are going to move very fast, and so we're always in this mode of trying to balance speed with accuracy.
I mean, I'm guessing, Andrew, that the team approach is equally important within the UK. Obviously, everybody's grappling with the same set of global rules, perhaps taking a slightly different approach. But it'd be interesting just to hear whether you feel that from a UK perspective there are differences in approach. Would you say that resonates? Kind of things being elevated quite quickly to management level?
Yes, I'd say so, because you can have you obviously need, as Devika said, you need to establish all of the facts and work out where is there an actual conflict? Are there any circumstances or exceptions in the rules which apply, which could enable you to act? And there might then be a decision that needs to be made by management whether you want to act, even if you could, even if you could get consent or do this or put in place an information barrier, and you might just think, we could do all of these things, but the risk of it going wrong might just be too much of a risk to take. So I think, as Devika said, it's getting information, it's getting to that point. It should be driven, I guess, mainly by the GC team. I think it probably does at some stage or some cases will require some management input.
And presumably, sorry to cut across you there, but presumably that also covers the risk of a client being unhappy, as you say, even if technically it is possible to act, or indeed there's no technical conflict on that particular matter. That sort of relationship conflict is a huge question sometimes.
Yeah, exactly.
Yeah, that's an interesting question, because a firm may have represented a corporate client for 20 years and not had a problem with conflicts. There could be, hundreds of matters that they have handled: transactional, litigation, advisory. But then comes along one new potential matter that can, uh, create a conflict issue. And these things are more, they get complicated because it's not just about the technical rules, and there are many which need to get applied.
And Andrew, am I right in understanding that there's actually sort of guidance for GCs, for in-house lawyers on sort of how they manage the sort of the competing aspects here, and how they consider their own individual positions as GCs and as in-house lawyers?
Yeah, so yes, I have published some guidance last month. Actually, it was published in draft to give people a chance to comment on it, and it is aimed at GCs and addressing conflict issues in particular, and trying to establish the key questions: who is my client? That applies both to assessing conflicts on new matters, but also to GCs conducting internal investigations, trying to working out who I'm actually advising in this situation. So you don't end up advising one of the individuals, for example, who's the subject of the investigation, or taking a partial approach. So yeah, the guidance addresses both those things, both client conflicts, but also how you manage conflicts as a GC when you're asked to investigate internal issues.
Thanks, Andrew. I'm not going to comment on whether a regulator providing guidance is in any way a conflict in its own right, but we'll see. That does sound like it provides some sort of insight for GCs. I wonder if I could invite each of you just to give me your top tip, if you will, on conflicts management. If a GC came to you and said, "What's your top tip on conflicts management?" What would you say? Maybe coming to you first, Devika.
That's a really interesting question. It's I think one needs to be very, very clear about what type of client we're talking about, because the rules for current clients, and that's normally the context in which this arises, are very rigid. If in New York the standard is differing interest, the rest of the country largely it's whether there is direct adversity to a client. So I think one has to be very, very technical as the GC to understand these rules very, very well, but also be practical in the approach, because the lawyer really has to create awareness about how these conflicts rules work. And you're dealing with lawyers who need to get started on work, and clients who are relying on the firm to take on the work. So I think together with being technical and practical, the third piece, I know you said one top tip, but I have to give three. The third piece is being sensitive to the culture and to the client's needs.
Thank you, Devika. I'm not sure she's left you much, Andrew, but as well as being technical, practical, and sensitive, is there anything you would add in terms of top tip, Andrew?
Well, I think as we talked about international practices, we do see the differences. So we talked about the UK system, which is very much rules based, as is the US, but it's slightly a different test, adverse or differing. So I guess the question is, if you find yourself in a situation where you've been acting for a client in the US, they then want to instruct you on a UK matter, it's not understanding how those rules interact, and it's also maybe looking at the highest common denominator in some circumstances and working out on global matters what standard are we applying, because it could come to a point where you're asked to do a piece of work in the UK quite quickly, and you're looking at it purely through the lens of the UK and not considering the international context. So I think we also see that in relation to other matters such as AML, where the standards vary from jurisdictions to jurisdictions, and if if you're not up to date and you're not on top of that, then you can spend sort of weeks trying to work out what to do, and clients can get left behind.
Thank you so much for listening to us today. We really enjoyed discussing these practice across the pond issues. As I said, we're planning for this to be a series of podcasts, of webinars, so that we can cover a number of transatlantic ethics and regulations topics. So we very much hope you can join us for the next one in the series very soon. Thanks again.